Hello, my name is Lauren. Will address those during their presentation. And in case you don't already have it, we'll be sure to share Amy and Sean's contact information. And so now I want to turn it over to Amy and Sean.
Thanks, Lauren. As Lauren said, I'm Amy Hebler. I'm an attorney with Fraternal Law Partners. I am joined here today with by my colleague, Sean Callan, who's a partner here at Fraternal Law. I think we've at least done work with a lot of you, and if we haven't had the opportunity to meet you all, Fraternal Law Partners are really a full-service law firm, and we've practiced in almost every area you can think of when it comes to Greek organizations. So there's a good chance that if you have a legal issue, we've either seen it or we've seen something that's similar to it, which kind of brings us to the checklist today, which I'll let Sean give you a little bit about our goals here and an overview of our intended outcomes.
Thanks, Amy. Yeah, and thank you to everyone who's checking in online today. We're very happy to have you here. And I hope you've gotten something out of this series of sessions that we've done here. I know we've enjoyed putting this together and then watching the other sessions as well. It's a great recap of most important concerns and issues that Greek organizations face, and they're sort of encapsulated here. And as Amy said, our goal in putting these sessions together is that we would come out of them at the end and have a document that we can share that's hopefully of some use to you in your work going forward. As you know from seeing the von Wayman and the Faber presentations, there's a lot of material that gets covered in these checklist sessions. We don't intend this to be overwhelming. It's a lot of material. We're not going to hit it in great depth. We're just going to sort of work you to these issues. And when we say a checklist, I don't mean to suggest that you necessarily have to review each and every one of these items annually or even more often. While all this stuff is important, it's not nearly as important as what you do day to day. You know, what goes on in your organization on a daily basis. These are simply things that we point out that from time to time in an organized way, whether it's every few years or whatever you decide, you might take a look at these items and just evaluate how your organization is performing. And that's really what we're hoping to achieve here. And Amy, if you want to throw up the slides, we can get started and take a look at the agenda and sort of see where we're going to go from here.
Yep, give me 1 second.
Yeah. Perfect. All right, Amy, can you get us started?
All right, so the way that we look at this, as Sean said, there's a lot of things to cover. So we're going to continuously try to break these down into different sessions. So here's kind of an overview of the categories that we thought we'd discuss today. The first one is corporate governance. Second one is more of an operations checklist. And then the third one that we'll briefly cover is stewardship. So to get us started with the corporate governance checklist. So when we say corporate governance, here are the items that we are going to talk about. 1, governing documents. 2, there's policies and procedures. 3, the committee charter. 4, the meeting documents. 5, the membership records. And then finally, the annual IRS and state filings. So a little bit about each of these. The governing documents, this is important for review for a few reasons. When we say governing documents, we're talking about your articles of incorporation and bylaws. If you're an unincorporated association, which a lot of chapters are, you're looking at your charter or any type of constitution. So that's what we're talking about when we talk about governing documents. A big thing that comes up, and a good reason that you should kind of continuously review these, is in terms of amendments. So if you amend your governing documents, do you know where the bylaws are as they have been amended? We've ran into situations where organizations have said, yes, we have these amended and restated bylaws, but they're unsigned. We don't know if they were actually adopted. So it's kind of best practice to have those dated and to know if they've been with the adoption date, so you know that they've been adopted. As a note, for articles, amendments to articles of incorporation, those amendments are not effective until they're filed with the Secretary of State. The bylaws will be effective once they're adopted, but the articles need to be filed with the Secretary of State. So we've also ran into issues where organizations have been operating as if those amendments had been adopted, but they'd never been filed with the Secretary of State. So again, it's just good to have that review of, do we know what governing documents are currently in effect, and do we have the date that they were adopted and the date that they were filed for the amendment articles? Also, generally in almost every state, if any provision in the bylaws conflict with a provision in the articles, then the articles will govern. So that's important when you're looking at amending those bylaws, to check to make sure it's not going to conflict with some type of provision in the articles of incorporation, because then those amendments to the bylaws would just be governed by the conflicted article amendments or provisions in the article. So that's something, if again, to check, make sure that you don't have any conflict in between those documents, so that you know what your documents say. Another thing is, do they reflect your current operations? A lot of times with the articles, those are pretty simple. They generally have your purpose provisions in there, some dissolution provisions, maybe a registered agent. So those are a little bit more bare bones. Where you really get into the meat of things are those bylaws. The thing about current operations is, if your bylaws or articles have something in it, say like this, that says the corporation shall only hold a property not to exceed the value of $50,000. And then if you're a house corporation, you're about to embark on a campaign to renovate your chapter house, or maybe even buy or construct a new chapter house, and your property will then exceed that amount, then you're not going to be in compliance with your governing documents. So sometimes these documents haven't really been looked at for years or decades, especially with these older organizations. So it's just good to review those governing documents, maybe annually, if not annually, maybe every 2 or 5 years, just to make sure that they reflect your current operations. The other thing we wanted to touch on is IRS requirements. So we've seen in certain situations where the bylaws or the articles have been amended to reflect the current operations, but then they no longer meet the requirements that the IRS has for certain organizations. Just as a reminder, 501c3, those are your charitable and educational organizations. House corporations will not be 501c3s generally, because owning and operating a chapter house is not charitable or educational. So usually you're looking at 501c2 or C7. C2 are those title holding corporations. You have to have language in your governing documents that say that it is formed exclusively to hold title to property, collect income therefrom, and then turn over all of the excess income to an organization that's also exempt. There are certain requirements for that need to be in your governing documents. So that's my caution there, is just make sure if you are amending your governing documents that they do still comply. Same thing with C7s. Those have to be exclusively for social and recreational purposes. And you'll have some provisions in there with membership requirements and so on and so forth. So make sure you're reviewing those. Again, if you're going to do an amendment, make sure it doesn't conflict with the articles if it's in the bylaws, and make sure you know where there's documents, the current effective documents are. Another thing is the policies and procedures. Always good to have certain policies and procedures in place. Here are 4. They aren't necessarily the most important, but just things to think about. If you don't have them, you might want to look into getting them, depending on what organization you are. Conflict of interest policy is always a best practice to have. That essentially is to protect the organization's interest if it's contemplating entering into a transaction that might benefit a private interest of someone like an officer or director. When we say it could benefit, that could be a financial or a personal interest. And it does not necessarily mean that the organization cannot then enter into that transaction. It's just saying you have to go through the proper avenues to do so, such as disclosure, then that person recuses themselves from the discussion, and the organization can decide what's best. So it's good to have that in place. If you're a 501c3, the IRS definitely looks for that. Document retention policy, always good to have that. Again, that needs to be reviewed. Your documents need to be reviewed as they're set forth in that policy. If it's every 7 years, it's every 2 years. You should follow that. You'll get in trouble if you're just kind of willy-nilly applying that. And then you have some documents that aren't there and some that are when litigation comes up. So if you have that policy, make sure that you follow it. It's for efficiency. It's so that you don't have mounds of files. If you don't, it's not necessarily to do so. But make sure that those are complying with the local, state, and federal rules in terms of document destruction. And then also, if any litigation arises, then you want to stop that destruction, and that would be in that policy as well. The investment policy, the purpose of that is just to make sure that the and prudently managing its investments, making sure that you're managing the portfolio and considering the purposes of the organization, and any really stated purpose of a fund. So really that's how management and investment decisions will be made. And you can review that, see whether any policies need to be modified. Spending policy, very similar, but that's to express the organization's procedures for dispersing funds from any endowed funds. Then you'll minimize the types of problems such as erratic spending, or if you're looking at how to do any administrative fees and spending rates, that would be in that type of policy. So again, to review that to ensure that the policy is in line with the organization's financials and their mission. The last two are more applicable to foundations, but the first two are applicable across the board. Here's just an example of that conflict of interest policy. This is an annual statement. You don't have to do it annually. It's probably best practice too. But if from a practical standpoint, you need to do it when a director and an officer is elected, then that was probably fine. But just to have this statement disclosing any current conflict of interest and then notifying the organization if any conflicts come up. Committee charters, I'm not going to spend a lot of time here, but just review your committee charters if you have any. Is there a defined purpose? What authority is granted? What are the roles and responsibilities? Confidentiality, board members will have in their fiduciary duties, they'll have to keep information confidential, but if there's any non-board member that is on the committee, they don't have that same duty. So you might want to look into some type of confidentiality agreement so that anything confidential discussed at committee meetings would be kept confidential. And then I'm going to kick it over to Sean to discuss the meeting document.
Yeah, thank you, Amy. Just to backtrack for a second, a couple of things to keep in mind. This idea that our bylaws don't reflect current operations, that is a major problem. Maybe not so much at national organizations, but at our smaller organizations, and in particular house corporations. I serve on a couple of boards right now, and on at least one of them, I don't think we're doing a very good job of following our bylaws because it's not possible. We have term limits in our bylaws, and nobody really wants to serve in this position. So we have board members who have served for a long time, and it doesn't reflect what's written. So that is a problem, like I said, particularly with smaller groups. I'd also point out in the discussion of compliance with IRS requirements, there's a specific, there's two questions on the 990 that specifically ask if the organization has a conflict of interest policy and a document retention policy. So those two at a minimum, you're going to want to make sure that you have, that it's clear and that we're following it. Now turning to meeting documents, this is really getting into the granular nitty gritty of this stuff, but it becomes important. And the first thing that we've got up here is the proper notice. And there the two issues are, have we given enough notice? Have we given notice far enough in advance of whatever meeting it is we're holding? And then how did we give that notice? I mean, do our documents allow us to give notice by email? Can we post a chapter house? I mean, how do we give notice of these meetings? These notice questions, most of the time don't matter. You know, for the normal routine day-to-day stuff that a board does, you know, people will know when the meeting is, they'll show up, you know, even if the notice is defective in some way. It becomes critically important when we begin looking at actions that could be controversial. And when things could be controversial, the very first thing opponents look to is, was there proper notice of this meeting? Was it given far enough in advance? Was it given in the proper manner? So it's good practice to know what's required, and sort of bake that into your operation so you do it as a matter of routine. So when we do have these sort of higher level meetings and actions, we know that those are good. So that's the first thing. An agenda, you know, the agenda is in and of itself isn't that important. I mean, it's helpful to everybody to have sort of an outline of what the meeting is going to cover. That also goes hand in hand with a notice, so that, you know, you can give notice of specific items that you might cover in a meeting and have those reflected on the agenda. But what the agenda can help with in the heat of a meeting is, number one, making sure that someone does a head count, right? To make sure that we actually have enough people here, a proper quorum, that we could validly take action. Because if we take action without a quorum, it's meaningless. It doesn't do anything. So generally, when I'm running a meeting, it's sort of the first thing we do is we'll do a roll call and evaluate whether we have sufficient people attending to achieve a quorum. And then secondly, the agenda, you can use the agenda to outline where in the meeting process you actually take, because sometimes you can have a meeting, everybody sort of agrees that this action should be taken, but the corporation board never actually votes. And again, if we don't vote on it, it's not an effective action. It's not a valid action. So the agenda can kind of be like a cheat sheet to sort of help us make sure that we follow proper procedure. And then finally,
Hello, it looks like we're experiencing some internet issues with Sean's connection. Amy, are you able to kind of pick up where Sean left off?
Sure. So for the minutes, that's kind of important too, just to document, and hopefully Sean can hop back on. But really, if you're voting on things, again, a lot of times this doesn't come up and it's really not controversial. But when things do come up, they're going to look back at the minutes and say, what were the votes for, who was against, who's voting for and against, and that's documenting that discussion. Because essentially you're building the record to support your decisions. And from the board, you have fiduciary duty, that duty of care. So you're going to want to document those discussions, show what you've considered. And that goes back to that conflict of interest policy. You're documenting that someone has recused themselves, that you've considered other options. And it goes back to also adopting any type of amendment that you have that, and you have that documented in the minutes. So if for some reason you can't find documents, you can look back at those minutes almost as a secondary resource. So it's just important, and making sure that you're going back and you're keeping those for voting by action by written consent. If it's not an in-person meeting, it's important to have all of those written consent signed to show that you are complying with state law and you do have the sufficient votes, again, to carry out an action. So membership records, a couple of things. First, do you know who your members are? That goes across all of the organizations. We've ran into situations where maybe membership provisions in the governing documents were a little bit different than how an organization had been operating, or also situations where the membership provisions weren't necessarily clear. And otherwise too, if there are qualifications for membership or there's a vote for membership, how do you get those new members? Are you following the process for new members? What about removal of members? Are you following that process? Do you have conditions to membership? If you do have conditions to membership, then are people complying with those conditions? If those conditions are not complied with, then are you following those processes? Are you doing a waiver? So really find out who your members are. It's important too to have that updated contact information. That I know for you all from a practical standpoint is a very important thing. That's how you get in touch with, if you're the foundation, your donors, or the chapter or the house corporation, your members. But that updated contact information is important from a legal perspective as well, because of what we mentioned in the previous slide about those meeting requirements. And the notices is a lot of times what your governing documents will say is that proper notice can be sent to the last address on record. So having that updated contact information is important, so you know that your members are getting that notice and they're getting the information that that you need in order to effectively govern and operate your organization.
Hey, Amy. Sorry about that. I got booted off there.
That's all right. I gave a brief overview of membership records, John, but
Yeah, no, it sounded like you were right. Yeah, no, it sounded like you were right on it. And again, it's important to just sort of have a standardized and documented process for initiating your new members and recording when they become members of the organization. Because, you know, in litigation, we've seen some very strange things happen. You know, for instance, we had one situation where an alumni group actually initiated collegiate members into the alumni group, and they did this because the chapter itself had been the charter had been pulled, so the chapter didn't exist. But now we have this alumni group initiating members, I guess, into the alumni group, but it was very confused as to whether these men were members of a fraternity or not. Or, you know, the chapter initiates members and fails to give proper notice to the national. That happens, you know, not frequently, but it happens not irregularly. And so it becomes really important to know exactly who our members are. And then, Amy, I'm not sure if you talked about the house corporation issues that we run into, but a lot of house corp bylaws are written in such a way that membership is conditional. So, for instance, you could have a situation where an alumni member of the Miami University Alumni Club can be a member of a house corporation, but only if they sign the corporate register, whatever that is. And nobody knows what the corporate register is, where it is, if it exists, if it ever existed. And so you really don't know who your members are or how many members you have, which becomes really important when you're trying to figure out if you have enough members present at a meeting to establish a quorum. Because if you don't know how many members you have, you don't know what your quorum requirement will be. So keeping track of our membership records, both as house corporations and as fraternities and sororities, is critically important. Just understand and know who our members are.
Yeah, and that's a good point, Sean. For organizations that are exempt under 501c7, which is a lot of house corporations, one of the requirements is that your income, substantially all of your income, is from members. And so when we're talking about conditions to membership, that's important. If there's something where we've run into of things like all the undergraduates will automatically become non-voting members, or all the undergraduates will become non-voting members upon written notice to the secretary of the organization. So that's fine as long as, you know, you're fulfilling that requirement. But if you're not, then those undergraduate members living in the chapter house paying rent are not technically members of the organization. And then you have a tax exempt issue because not substantially all of your income are from members. So things to keep in mind. And that's a great point, Sean, about the specific examples that we've ran into, and not even just conditions, it's just overbroad membership provisions of saying everyone in the sorority are members of this house corporation. If you have a percentage of quorum, then it gets really sticky because if you're saying everyone of the sorority, that's going to be a very high number. So yes, exactly, some great things to keep in mind. So just briefly, annual IRS and state filings, this pops up every once in a while with us. It's important. We see the issue here of a transition if you have new officers coming in, making sure that those state annual reports and fees are filed. If you don't file those, then the state could say they could either administratively dissolve the organization or you're no longer in good standing with the state. It's important. You have to be in good standing to operate within that state, but it becomes very important when you have things like loan documents, because a lot of lenders will include language in their loan documents that say that the organization has to be in good standing. And if you're not, then that could be an event on default, and then you could possibly have some acceleration clause. So it's important to have those filed and make sure that you are in good standing with the Secretary of State. You can log on pretty much, I think most states, you can search your entity and see what your standing is. So keep that in mind. If there's any state tax filings, if you are exempt federally from taxes, that does not necessarily mean that you're also exempt from state tax. So just make sure that you look at both of those. The IRS annual return, we're talking about the Form 990 series. This is the full 990, the 990N, the 990EZ. It's important to file those. If you don't file those for 3 consecutive years, then you are at risk of, then your organization will be automatically revoked, your exempt status. So that's important. You can check actually to see whether you are currently revoked by going to the IRS website. It's their Select Check website, and that is up on the screen now. You can search by EIN, you can search by name. If your organization has been automatically revoked, it will have the date of revocation and a notice date. We've come across this several times. This goes across the board with all organizations, chapters that haven't filed their 990s, house corporations that haven't filed their 990s. And some of it been revoked since like 2012, but the organization, either someone got a notice or it didn't get communicated. So it's important to make sure that you are in good standing with IRS, your tax exempt status is in good standing. If it's not, we can help you with that to get that reinstated and maybe even possibly retroactively reinstated to the date of revocation. So just make sure you're filing those. It's come up a lot lately, especially with the new online electronic 990 filing, or make sure that you're under the exemption that you think you're under, because we've had some organizations that are actually on the IRS files as exempt under Section 501c2, but they've been filing as C7s, and now with the electronic filing system, they have to file as a C2. So all of that just to say, please file your taxes and your annual and state returns. All right, so that's kind of the governing documents. Next is the operations checklist. Here are a few things we'll be discussing. I won't read through them again, but I'm going to turn it over to Sean to kick us off with kind of from the more operations side.
Yeah. All right, Amy, thank you. The first bucket of things we're going to talk about, I suppose, are membership agreements. And, obviously these are important agreements. These define the relationship between our organizations and its members, which is, the heart of our organizations. It's fairly apparent that this is a very important document, something that should be looked at from time to time to make sure it's capturing that relationship in a way that we are happy with. I can tell you the sort of general matter. My thought on these is shorter is better. I've seen some very long membership agreements and some very short ones, and in my view, the short ones do as good a job as the long ones, with the added sort of benefit that they're understandable, and people might actually read them before they sign them. So that would be nice too. Some specific provisions that we've looked at recently include name, image, and likeness consents. We have seen a lot of organizations getting pushback from members when those members' picture shows up on a website or in a marketing material or wherever. I don't know what's triggering that, if it's got something to do with the name, image, likeness discussions in collegiate sports. But we've had a lot more questions and a lot more disruption over this issue. So what we've recommended, and some organizations are doing, is just putting that consent right into the membership agreement. So as soon as you become a member, you've already signed something that says, we as the organization are allowed to use your name, image, and likeness in our materials. So that's one issue. The second issue, and this isn't for everyone, I understand that, but we do have organizations we work with that like to have an arbitration clause in their membership agreement. And this arbitration clause wouldn't govern every dispute that may impact a member or a chapter, but it would govern venue for disagreements or disputes between that member and the organization. And that can certainly be helpful if you get sued by a member who has signed a membership agreement containing an arbitration clause. You can move to stay that litigation. And generally speaking, courts will grant that stay and recognize the arbitration provision. So again, that's an individual organizational call, whether they want to take that approach or not, but it can be helpful. The third clause that we've been working with regularly are indemnification clauses. And these can be extremely helpful. I know some organizations have used them to great effect. What they basically provide is that if you as a member violate our rules or policies or procedures, then you as the member will indemnify us, the organization, from and against any harm arising from that violation. And you can think, I'm sure, off the top of your head of many situations where this might apply. You know, this isn't for everybody. There are a lot of organizations that find this to be anathema, the idea that, you know, we could potentially sue members, or that we would take this position with our members. But you know, if it's something that works for your organization, then and it's certainly something to think about. So that's what those are sort of, at least in our experience, kind of the new things going on with membership agreements. So if you can flip the slide, Amy, maybe you can sort of tell me when you're ready, because I'm not seeing this PowerPoint right now.
Okay, we're good to go.
All right, so continuing with our operational checklist, you know, it's good to take a look at our policies on a regular basis. And again, much like our bylaws, make sure, number one, we're following them, and number two, that what we're doing in the field is actually what's written on the piece of paper. The risk management policies, I mean, that the importance of those policies is somewhat apparent. I don't think we have to spend a lot of time on this. Favor spent significant time on risk management and insurance considerations. So I don't think we need to reinvent the wheel here. But it is important that you work with your insurance carriers and maybe your counsel as you review your risk management policies, and make sure that they are current, consistent with your insurance program, and accurately reflect what you're actually doing in the field. Social media policies, these are becoming more and more important. We are seeing a lot of questionable social media activity, both in social media channels that are related or even owned by chapters or parts of the organizations, as well as personal social media accounts. There's any number of issues that can arise out of these social media channels. We're seeing a lot more discipline cases arising out of social media activity. And it's important to have some sort of articulated policy so that we can take those disciplinary actions when necessary. I know oftentimes when we hear from a student who's facing discipline for a social media event, we'll hear freedom of speech and this, that, and the other. Well, again, there is no freedom of speech when you're in a fraternity or sorority. But if you outline what's acceptable and what's not, and along with some wiggle room, because new things are being invented all the time on social media, it will give you a lot better footing to impose discipline or otherwise shut down social media that you may not like. And then finally, discipline policies are important. Again, we start from the proposition that we are all private membership groups. And in that kind of setting, there is no right to due process. Right? So the organizations, you decide what process is due. And you communicate that process, what we're going to provide you in terms of due process, through your discipline policies. So when we think about how our disciplinary decisions will be reviewed in hindsight, whether by a court or by an institution or whoever may have occasion to review our decisions, the due process that we must afford is, one, notice and a meaningful opportunity to be heard. So notice of the charges against the member and a reasonable opportunity to be heard about those charges. And then two, we need to follow our rules and procedures as written, right? Not pursuant to some made-up notion of due process or constitutional notion of due process, but whatever due process we have decided and written is due. So these rules should be, and the policies should be written in such a way that they're easy to follow, and they shouldn't be overly expansive. It should outline a fairly simple process that chapters, alumni, whoever may be implementing these kinds of disciplinary actions can follow reasonably well. And that's all I had about those policies. Amy, I don't know if you have anything else.
No, I think that's good. And just remember, as Sean said, if you put the term due process and you capitalize it in your documents, then that holds a legal significance that maybe you don't want it to. So just to be clear about what exactly your process is, as Sean has mentioned. So, but that's all I got. We can move on to vendor agreements.
All right, vendor agreements. So, vendor agreements, they're often boilerplate. There's many times not much we can really. Vendor agreement. Sorry, I was trying to catch up on the screen. We get a lot of boilerplate sort of contracts that don't really lend themselves to a lot of negotiation and modification. We can ask for that, but we get mixed results with that. But what we can say, generally speaking, is you're going to want to review these carefully before signing. I mean, they are legal documents. They do have terms and they do have consequences, and some of those terms can be onerous. So we do want to make sure we understand what we're signing. It's a lot of small print, but we try to make our way through it. And if there's something you don't understand, then you should ask for clarification, because there are sneaky things at times in these vendor agreements, charges that don't quite make sense or charges that can't be quantified. One provision that is often hidden but can cause major problems are auto renewal provisions. So you want to look carefully for that. And then termination rights. Understand what it's going to take for you to exit this agreement if you're not happy with it. And how much will that cost and how quickly can you do it? And so, even if you have what would otherwise be considered an onerous contract, if you've got a vendor you like, you have termination rights that are reasonable, and you can get out of this thing, and there is no auto renewal provision, then, I'd feel pretty comfortable just taking a risk, You can say, I don't like the contract. I like the vendor. If it doesn't work out, I can get out. And there's not going to be some kind of sneaky auto renew that gets pulled on me. So those are kind of the high level things we look for on vendor contracts. And if you have a process in place that accomplishes that, then you're good to go. Anything else, Amy?
I guess the one other thing I would add is if you have an attorney that is familiar with vendor agreements, that can be beneficial, because if they've looked at the same agreement and have negotiated what can be negotiated, as Sean said, a lot of them, it's hard to, in their boilerplate, and it's hard to negotiate. But if something has been done before and a vendor is saying if they can't do it, then it's advantageous to go back to an attorney that has looked at that same agreement and talked to that vendor. And quite frankly, sometimes there's a good relationship there. So it is beneficial to have someone if they've looked at similar vendor agreements.
Yeah, great.
So the next is board evaluations. Not going to spend a lot of time on this. It's generally a best practice. Most organizations don't do it. They're good to have so that you can evaluate whether the organization is fulfilling its mission and meeting its objectives. It can be anonymous if you're looking at that, and have your board members evaluate how effective they think that they are being. Or quite frankly, if you're looking for new board members, of identifying the areas of need, such as if you need someone who's more financially savvy, then that could be something that comes up in that board evaluation. But just a best practice, again, doesn't usually happen. Sean, I don't know if you have anything else you want to add on that.
No, it's everything you read, all the literature you read, this is a best practice, and we probably should be doing it. But it's something you want to be aware of that's out there, and consider whether or not it's right for your organization. I think that's probably what I'd say about that.
Okay, so next is employee and contractor agreements. Since we're getting a little bit low on time, I'm not going to spend a ton of time on this one either, but just for employees versus independent contractor, make sure that you have, whichever way it goes, that they're classified correctly, and make sure your agreements with these individuals actually reflect the status that you think that they are, specifically like what the company controls, how they're paid, who controls their schedule. That is all going to weigh into that. And if you say that they're an independent contractor, and you have an agreement with them that says otherwise, then you're going to get into an issue where they're improperly classified. And if you have no reasonable basis, then you could be held liable for employment taxes for that individual. So just be careful, make sure you're reviewing your agreements and making sure that the individuals are classified correctly. Same thing with exempt versus non-exempt. An exempt employee can be paid salary and is not entitled to overtime. Non-exempt is entitled to overtime. And there is a salary threshold test and a duties test for that. A note on that, there's a proposed rule that was proposed September 8th that would increase the standard salary level. And that would increase to, I think it's $1,059 per week, or $55,000 or $55,068 annually. So be aware that has not passed yet. To my knowledge, it's still proposed, but if you do have both exempt and non-exempt employees, be aware of that. The penalty for being wrong on that one would be back pay, including unpaid overtime compensation. And in those cases, that would be 24/7. And those liquidated damages equal to back pay. So basically double damages. So it's very important that you have these individuals classified correctly in both employee and independent contractors, and exempt versus non-exempt. A handbook, do you have one? If you do you review it annually? Does it accurately reflect your operations? Have someone look at that. It's important that you don't have conflicting provisions in that either. So just kind of as a heads up to, if you don't have one, it might be something to look into. Moving along, operations checklist. It was so long that we did it in 2 parts. So we're going to continue on to these next couple of topics for kind of the second half of operations, starting with the executive director position. I will send that to you, Sean.
Yeah, so the executive director, when we look at that position, it's the most important staff position in the organization. It's most likely the highest paid position in the organization. And and it's the face of the organization. That's who people see when they contact our organizations and who they want to talk to. The face of the organization to our institutions, to other groups. It's a critical position. In the arrangement by which the executive director is employed, deserves regular attention just to make sure we understand what that contract says. And that's the first point in our bullets here is, do we have a contract? Not every executive director has a contract, and that's fine. At the same time, I think there are benefits to having an agreement for that position, given its importance. The job description, is that accurate? Because we do want to be able to, accurately assess, performance against, something that's fair and reasonable and that all the parties have agreed to. If the job description says something that's wildly different from what our executive is being asked to do, then that's not really fair to either party. Here, unlike with our boards, I do think it's important that evaluations be done annually, if not more often, because the evaluation is a two-way street. I mean, first, it allows the board to weigh in on what they like about the executive director's performance, what they may not like, if they see something that needs to be improved. And at the same time, it gives the executive time to respond to whatever board concerns may arise. So if we evaluate regularly and we keep those evaluations and build a personnel file, then each party is going to understand what the other one needs and what the other one is doing. The compensation criteria, it's not exactly straightforward. I think most groups do a pretty good job at this, but basically within the nonprofit realm, when you're figuring out how to pay your highly paid employees, you want to kind of look to the market and sort of see what other groups of similar size and complexity are paying their executive director, and then slot the compensation sort of in and around where the other groups are. With consideration to particular value that this executive may have or particular longevity at the position. I mean, there are other factors that are going to require adjustments to what you're seeing in the market, but it should start with a market-based analysis and then adjustments from there. And then you always want to sort of, just like with any kind of contract, you want to understand how you exit, and that goes, again, that's on both sides. The executive is going to want to know how they can get out if they're unhappy or need to move, or life changes or whatever the case may be. And the same with the organization. That's about all I had on executive directors.
Sean, we actually had a question from the audience for you and Amy.
Yeah.
How would an organization deal with a third party that is comprised primarily of organization members and uses related imagery to promote social events separate from the organization?
That sounds like trademark infringement. I mean, it sounds like it's an event that's not affiliated with the organization, and their marks are being basically infringed to promote that event. Am I understanding that right?
That seems to clear it up for me. If the person that submitted the question needs some further information, we will be sending out the contact information after the event. Feel free to shoot Sean a note and he can clarify for you.
Yeah, I mean, if that's the case, then I think I would just try to send a cease and desist notice and see what happens.
Yeah, and that's a good point, that in your vendor agreements, you might want to see how the vendor is allowed to use your marks and your name and your image and likeness of the organization, and see if you have to approve before they have some type of event too. So that's something you can look for in your vendor agreements. Again, they might say take it or leave it, but that's a good point. All right, so potential foundation grant. So this is just kind of know what your options are. a lot of national foundations will offer some grant opportunities for either the fraternity or local chapters or house corporations. Usually those are in, I'm not going to go into depth into these, but those educational area grants, there's historic preservation grants, grants just for educational furniture, which are those furniture in the educational areas of a chapter house. Internet grants, if you have to rewire your house, that would be 100% fundable under the IRS guidance. Operating expense grants, there's 2 buckets for that. If they're directly allocable to educational areas, then 100% of that would be fundable. If they're not, then the educational percentage of the chapter house would be the basis for that analysis. And then lastly, programming grants for educational programming. So just know that those are out there as options as organizations. They might be annual or biannual review of those might be beneficial depending on what your needs are. And then just make sure you're complying with any reporting or monitoring requirements if you do enter into those grants. Look at that grant agreement for those requirements, and just make sure that you're doing what you say you're going to do in those, in terms of the reports that you'll provide to the foundation, which is required under the IRS guidance. So good to have on your checklist just to review, because it might be beneficial and you may be able to get some foundation funds to assist in your activities. Leases and occupancy agreements. This comes up a lot, especially at the beginning and the end of the school year. Do you have written agreements? And if you do, are they signed? We've run into situations where they were only signed by one side, or they had an agreement, but it wasn't signed, but the individuals were living in the house. So just make sure you get those signed. Do you know what they say, or regularly review the language? It goes back to what are the termination provisions, and that's that last bullet point for both if you are entering into it with members or leasing from a third party. Do you require a guarantor? If you're leasing with individuals, probably a good idea, so that you're guaranteeing that that is going to be paid. So it's good to have those on those member individual leases. The right to generally occupy a house, not recommended to put a specific room, but you can say that the house corporation has the authority to assign different rooms. Is there a process for reviewing applications? And if there is, are you abiding by it? That especially becomes important if there is a discrimination claim and they're claiming that they were treated differently in the review process or the lease review or occupancy agreement process. So things to keep in mind, we could probably spend an entire hour on occupancy agreements, but as you review and as it's on your checklist, just make sure you know what they say and that they're signed. And then again, suggest that there's a guarantor. John, I don't know if you have anything you want to add for that overview.
No, that's really it. It's just keeping track of all the agreements and making sure they're signed.
All right, so then I'll kick accommodations over to you.
All right. So we could certainly spend an entire hour on this, probably more. But just suffice to say that FHA claims have come up more and more often in our space. This deals with discrimination against persons with disabilities. We see this most often in medical excuses to live out and to support the request for an emotional support animal in a chapter house. These are, in our view, lawful claims. We believe that FHA does apply to chapter housing. We are exempt from ADA, but generally speaking, we're not going to be exempt from FHA. The main thing to take from this for checklist purposes is, do we have a policy? Are we consistent in our review of these requests? And I have committee down here because we found that some groups deal with these by way of a committee. And that does a couple things. First, it gives a small group of people deep expertise in the area, and they can make these determinations and evaluations based on that experience that they gather by serving on this committee. And secondly, when you have the same people looking at it over and over and over again, that really helps you with your consistency in review and results. So, for sure have a policy, because these claims are coming up all over the place. And make sure that you are open to accommodation requests and you have some policy in place to handle that. And then consider, whether a committee type situation would be good for your organization. And I guess all we got time for on that one, Amy. Well, it could be lengthy.
Yep, we'll move on to the real estate taxes.
Yeah. So this kind of goes in the real estate and property bucket of thinking about your organization. And the first question is, are we exempt or not? This would apply to both HQ buildings and chapter houses. And then secondarily to that is if we're not, is there an exemption available? And if we can just hit the slide, Amy, just hit them all and just bring them all up. Amy?
Yeah, one more.
Yeah.
You should be good.
Okay. So is an exemption available? Oftentimes you'll have a situation where you come into ownership of a facility where there is the exemption is automatically lost on a transfer of title. So when you first take title to a facility, it won't be exempt, but there may be one available. So it's always worth looking into. If not, then you need to understand your bills. And so understand when they're payable, and most importantly, who gets the bill, because it could be going to a volunteer's house somewhere and you don't know where the bill is as an organization. So check your tax mailing address, understand if it's billed in arrears or current. This is very important when you go to sell the property. And then consider whether the bills are based on an accurate valuation. In pretty much every jurisdiction I'm aware of, there's an appeal allowed if you feel like your property is overvalued.
All right, so last thing is the stewardship. Since we're pretty much out of time, just a general review of this. Look at how you're stewarding the charitable assets. When we talk about that, especially look at your restricted versus the unrestricted funds and board restricted funds. We've seen that come up a lot. A couple of issues of how you invest that and make sure that those funds are truly separate. You want to only use those restricted funds for its restricted purposes. Any board restricted funds is a little easier to remove the restriction because the board has put that restriction on. But again, make sure you have the paperwork, make sure you have your donor agreements, because if you don't, that's where it gets confusing of who exactly put this restriction on these assets. Again, know where those funds are. If they are no longer practical or it's impossible, then you want to look at releasing those restrictions from those restricted funds, and we can of course help you with that. Disclosure and transparency, make sure you're disclosing things on your 990, make sure you're giving donor receipts if you're foundations. It's important for them to get those receipts. That has been coming up lately too, not necessarily in the Greek world, but more of a general point. And then that third one, structuring set-aside funds. Those set-aside funds, the chapter or fraternity can set aside investment income to be used for religious, charitable, scientific, literary, or educational purposes. If it's not properly set aside, if it's properly set aside, then it's not subject to the tax on unrelated business income. So again, that's just another way to take advantage of kind of your tax situation, is having those set aside funds. You would then have to use that for various activities like scholarships or leadership types of training or any other type of educational programming. So just make sure that those are structured correctly so that you can take full advantage of that for your organizations when you're looking at really stewarding those charitable assets too. It all kind of goes back to that. So Sean, I don't know if you have anything else you want to mention on that.
No, I think you got it.
Okay, well, we ran through that very quickly. We wanted to make sure that we got all of you at least that overview. As Sean said, we know that this is overwhelming, but it's important to know because you don't know what you don't know. So this is, now you can look at that checklist and decide if there's anything that the organization needs to do in order to kind of be more effective and fulfill your missions and your goals.
Excellent. to have great people supporting the fraternity and sorority community. Please let us know what you would like to see from us in future series. And in closing, let's all have a prosperous and hopefully quiet year. Thank you.